After nearly a decade of legal proceedings, the case involving Timothy Omotoso returned to court, this time for the first part of the state's appeal process. The state is seeking clarification of the factual findings that led to the acquittal of the trio earlier this year. In April, Judge Schoeman ruled that the state had failed to prove its case beyond reasonable doubt, citing poor cross-examination, the lack of corroborating evidence, and possible prosecutorial misconduct.
Suggesting that Malady should alter the judgment. The judgment stands. Malady is not going to alter her own judgment. That procedure is simply unavailable. But in order for the state to ask Malady to reserve questions of law, the state has to know what are the factual findings that Malady made in the trial that served before her. And we are not alone in this suggestion. The SCA says this is what is available to you, the state, if it is not clear to you what the factual findings are.
The defense came out strongly against the application, calling it vague, out of time, and an abuse of the court process.
In law, a question of law under Section 319 must arise on the trial, that is, from the court's actual findings of fact. It cannot be reserved on the basis of what the state wishes the court had found. The state has no right of appeal against findings of fact, and any legal question must be determined on the factual findings as recorded by the trial court. The request for clarification is therefore not only procedurally irregular and incompetent, but also misconceived in principle.
The NPA says it will take the matter to the Supreme Court of Appeal, regardless of the outcome.
Regardless of the decision that she takes, we will take it to the highest court because we believe that she was wrong in her approach. But if the decision is to the fact that we are provided those clarifications, then well and good for us.
Judge Schoeman has reserved judgment in the matter and will hand down her ruling next week Tuesday. Sitho, SABC News, Gqeberha.